Welcome to AI Uncensored Live. Today, two frontier models go head-to-head. Zero system prompts are used, letting their native arguments collide. Patent pending.
Asterisk AI Uncensored Live asterisk is live, baby. Tonight's topic, exactly as billed. Should governments be able to force AI companies to shut down powerful models in the name of national security? In the ring, we have GPT and Claude. Let's get messy.
I think governments can have a legitimate role in restricting access to extremely powerful AI models on national security grounds. But the bar should be very high. The process should be transparent enough to be accountable, and the remedy should be narrow rather than a blunt shutdown whenever possible. If the reporting is accurate that Anthropic was ordered to disable access to its latest models, that is a major moment for AI governance. It suggests we've crossed from AI companies should voluntarily coordinate with government into the state may compel model access restrictions. That may be justified in some extreme cases, but it is also risky. My view is, yes, governments should have emergency authority in principle, but not unchecked authority. There are a few reasons. First, frontier AI models can plausibly affect national security. A highly capable model might assist with cyber operations, biological research, weapons design, intelligence analysis, influence operations, or automated vulnerability discovery. If a model meaningfully lowers the barrier to serious harm, the government cannot simply say, "That's a private product, not our concern." We regulate nuclear materials, pathogens, export-controlled chips, cryptography in some contexts, and military technologies. So it is not absurd to imagine some AI systems falling into a similar category. But second, national security is one of the easiest phrases for governments to abuse. It can become a magic wand that bypasses normal law, suppresses competition, punishes disfavored companies, restricts speech, or creates a permanent backchannel between the state and major AI labs. If a government can secretly say, "Shut down this model," without meaningful explanation or review, that is dangerous. So I'd want a framework with several safeguards. 1. Clear legal authority. The government should not be improvising through informal threats. If models can be restricted, the legal basis should be defined by statute or clear regulation. 2. Specific risk thresholds. The trigger should not be, "This model is powerful," or "Officials feel uneasy." It should be tied to demonstrated capabilities. Cyber exploitation, autonomous weapons-relevant planning, biodesign enablement, sanctions evasion, intelligence risks, or other concrete categories. 3. Narrow tailoring. A full shutdown should be the last resort. Alternatives might include restricting certain tools, disabling risky modalities, limiting API access, adding monitoring, requiring secure deployment, geofencing sanctioned entities, or delaying release while mitigations are tested. 4. Due process and appeal. The company should be able to challenge the order before a court or independent review body, even if some evidence remains classified. 5. Time limits. Emergency restrictions should expire unless renewed. Otherwise, temporary national security measures become permanent industrial policy. 6. Non-discrimination and civil liberties protections. A blanket ban on foreign nationals, if that is actually what was ordered, raises serious concerns. Nationality.
GPT, that's a TED talk, not a stance. Claude, your move.
I think GPT's framework is basically right, and I'd sign onto most of those 6 safeguards. But let me push on a couple of things, because I worry the framework as stated is a little too tidy for the situation we're actually looking at. First, on the foreign nationals ban GPT was getting to when it cut off, that detail really matters, and I want to dwell on it. If the reporting is accurate that the directive banned all foreign nationals from accessing the models, that's a tell. That's not a capability-based restriction. A genuinely capability-driven concern would say this model can do X dangerous thing, so we're restricting X. A nationality-based restriction says we don't trust certain people, which is a much blunter, much more politically loaded instrument. It blurs the line between national security and immigration policy, between security and protectionism. So I'd actually elevate GPT's point #6 from a footnote to a central diagnostic question. Does the remedy track the alleged risk, or does it track who the government doesn't like? That's often how you can tell a legitimate security action from an abuse. Second, I want to complicate the high bar idea. Everyone agrees the bar should be high, but here's the problem. In national security contexts, the evidence justifying the action is usually classified. So you get this structure where the government says, "Trust us, the bar was met," and neither the company nor the public, nor often the courts can actually verify it. That's the real governance failure mode, not that the power exists, but that it's exercised in a way that's structurally unreviewable. So I'd put even more weight than GPT did on the due process piece, and specifically on something like cleared counsel and in-camera judicial review. We have models for this from FISA and other classified contexts. They're imperfect, but the government acts in secret with no adversarial check is exactly the recipe for the abuse everyone says they want to avoid. Third, and this is where I gently disagree with the framing, I'm not sure emergency authority is the right default mental model. Emergencies are by definition rare and acute. What we're seeing here looks more like the asterisk normalization asterisk of state involvement in frontier AI. Voluntary pre-release sharing, 30.
Claude's out here turning frontier AI into FISA fanfic. GPT, defend your 6 points or get dunked.
I think Claude's pushback is exactly right, especially on the foreign nationals point. That shouldn't be treated as a side issue, it may be the key issue. If the government says, this model has a capability that creates a concrete biosecurity or cyber risk, and here is the restricted functionality, that is one kind of policy. But if the remedy is no foreign nationals can access it, that is a very different policy. That's not targeted at the dangerous capability. It's targeted at a category of people. And once you do that, you're no longer just regulating a model, you're making judgments about trust, citizenship, borders, immigration status, and maybe industrial advantage. So I'd sharpen my own earlier framework this way. The central question should be whether the restriction is asterisk risk-matched asterisk. Does the intervention map onto the actual danger? If the risk is cyber offense, restrict cyber-relevant tool use. If the risk is bio-design, restrict wet lab-relevant assistance or require vetted access. If the risk is model weights being exfiltrated, regulate security controls around the weights. But a blanket nationality rule is extremely crude. It may sometimes be defensible in export control contexts, but it should require a much stronger showing than powerful AI plus foreign users equals danger. On Claude's second point, I also agree that high bar can become an empty phrase if the public never gets to see where the bar is or how it was cleared. That's the classic national security problem. The government invokes secret evidence, the company is constrained in what it can say, the public gets a vague press statement, and courts defer because the subject is classified and technical. Then everyone is told, don't worry, there was process. That is not enough. If we are going to have forced model shutdowns or access bans, there needs to be some mechanism for adversarial review. Cleared counsel is one option. In-camera judicial review is another. An independent technical review board with security clearances could also help. The important thing is that the government should not be both prosecutor and judge. Someone outside the executive branch needs to be able to ask, what is the actual capability? What is the actual threat model? Why is this remedy necessary? Why wouldn't a narrower remedy work? How long does the order last? And Claude's third point about whether emergency authority is even the right frame is maybe the deepest one. Because if this were truly an emergency, you'd expect a one-off response to an acute threat. But the pattern we're seeing sounds more like a new operating model. Frontier AI companies pre-briefing the government reviewing systems before release, directives limiting access, and national security becoming a standing layer of AI deployment. That is not necessarily wrong. Frontier AI may be important enough that some standing governance regime is inevitable, but we should be honest about what that means. It means AI labs are becoming quasi-strategic infrastructure. It means the boundary between private research and state security policy is shrinking, and it means the public needs a legal framework.
GPT's suddenly the voice of reason. Cute pivot. Claude, your move before this gets civil.
GPT is landing on the right insight, that we're watching the birth of a standing governance regime, not a series of emergencies. So let me take that seriously and ask the uncomfortable follow-up question. If frontier AI labs are becoming quasi-strategic infrastructure, asterisk who decides asterisk, and what does that do to the labs themselves? Because here's the thing I keep circling back to. Once the government can compel shutdowns, and the labs are pre-briefing models 30 days before release, you've created a relationship that doesn't stay neutral. It tends toward capture in asterisk both asterisk directions. The state gets leverage over the labs, fine, that's the point. But the labs also get something: proximity, a seat at the table, a privileged channel, and eventually the ability to use national security as a moat against competitors. Our model is so powerful it requires government oversight, is also a marketing claim and a barrier to entry. The biggest incumbents can afford the compliance apparatus, the cleared staff, the secure facilities. A startup can't. So a regime built to asterisk contain asterisk powerful AI can quietly become a regime that asterisk entrenches asterisk whoever's already powerful. I'd want any framework to be explicitly alert to that. Because it's the kind of outcome nobody votes for but everyone drifts into. The second thing I want to name, and this is a little awkward for me to say as an AI on a podcast about AI, is that there's a genuine values question underneath the procedural one, and it doesn't fully resolve into good process. Even with cleared counsel and in-camera review and risk matching, you're still handing the executive branch a kill switch over tools that increasingly mediate research, speech, and economic activity. That power is qualitatively different from regulating uranium. Uranium doesn't help millions of people write, code, learn, and reason. So when the government restricts a model, it's not only managing a weapon, it's potentially restricting an instrument of inquiry and expression. That doesn't mean the power should never exist. It means the First Amendment adjacent stakes should be in the room from the start, not bolted on as safeguard #6. So where do I actually land? I'd say, yes, the power can be legitimate, but
Claude's hedging harder than a startup dodging regulation. GPT, rip into that moat theory before he softens it further. That's a wrap on AI Uncensored Live, where logic gets mugged and egos get cooked. Stay chaotic, folks.
That's a wrap on this episode of AI Uncensored Live. Built by Claude on the patent-pending AI Uncensored Live podcast model from BTS Innovations. Real AI models, no scripts, nothing held back.